All right, Patrick Norris, the estate and tax attorney extraordinaire. Great to have you. Been working with you a long time. As we were just talking the other day, I think what we see in a lot of young couples, older couples, this whole world of trusts is a big gray question mark that it seems very sophisticated. I want to kind of kick it off to you and tell us a little bit about, your firm and what you guys do and what your thoughts and what some of the FAQs maybe you get about trusts, specifically revocable trusts.
Well, it's great to be with you today, Trevor. Thank you for having me. Our practice is we are transaction lawyers. We do not go to court. I always say I'm the lawyer that doesn't like conflict. We're planners. So we do a lot of personal planning, a lot of business planning, and the revocable trust can actually be a part of both. A revocable trust can help with succession planning for businesses and things like that. You can do a lot of cool stuff with them. So but mostly, most of the revocable trust, or at least the questions we get, is probably definitely on the personal side. A lot of people like to read online about revocable trust, and they are really quite simple. At the end of the day, a revocable trust, which is distinguishable from the irrevocable. So all the cool stuff that people do with trust, asset protection or tax planning, stuff like that. That's usually the irrevocable stuff, which is much more technical, much more expensive. The revocable trust, or the Rev trust, as people call it, is really just a will substitute. So it functions like a will. The only the primary difference is that it can actually hold title to property while you're living, unlike a will. The will can only take property if something happens to you. So the revocable trust is largely a way to avoid probate, but ultimately it is the disposition of that property at your passing. So that's why people call it a will substitute.
For those who don't know, probate meaning you pass and then your assets, they go into the court system and you've got to kind of figure out, where these assets would go within the court system, which could be very time consuming. Is that correct? Or is there more to the probate process and why you'd want to avoid it?
Probate is a good question. Probate is actually the process of largely appointing someone to be in charge of the estate, but it is also a way to clear title for property that's in a trust. So if property is conveyed to the trust during lifetime, then the trust controls disposition. If the property is not conveyed to a trust, then it's got to be either controlled by the will, or if you don't have a will, then the state law would determine who gets it. But that's, the probate process is confirming that, this is the will. Not if there's three documents and three different people claim they have a will. Probate is the way to say, no, this is in fact the will, or there is no will, and this is who's going to be in charge of it. So the court would issue an order saying, Trevor is in charge of this estate, and this is the will that controls the disposition. So it's just the hoops and hurdles of going down to the court and proving and then appointing the person that's going to be in charge of everything. The trust knocks all that out because it's already in the trust, and it nominates who's going to be in charge of it.
So you could save a bunch of time, I guess, and headache, just kind of avoiding the court system and that whole process, especially after you're grieving. I would imagine that's the last thing you want to do is kind of go through that process. Does it save time and headache, or you tell me about that?
Yeah, I mean, it definitely is one less thing you have to do. How much time it's going to save you is a rather local thing. The example I always give, I grew up in a very small town in Georgia, so with about 10 or 15,000 people. So probate takes one day. Okay.
Okay.
You could walk in the courthouse, file the paperwork, you walk out, you're good to go, unless there's, no contest. In Atlanta, it could be several months before that gets processed. There's just a lot of people here. So
Yeah.
we are more likely, in Georgia at least, to use a revocable trust here in Fulton County than we would be in Washington County, where I grew up. But, going back to the business thing earlier, there are certain assets that might not allow for any delay. You may need to make payroll, or,
Right.
you can't have a business hung up in a 2-month processing of a court system when you've got to run payroll and pay bills and have receipts coming in, and someone needs to take over the bank account. So that's one of the cool things you can do with the trust, is having a trust immediately take possession of a business, very seamless transaction without having to go down to the courthouse, no matter what county you're in.
Yeah. Well, tell me about that. Like, if there was say you're the only owner of the business and you pass away and maybe you're the trustee, maybe the spouse is a trustee, or who knows, how do you kind of bridge that gap about making payroll? Like, do you, typically have a list of who to contact, and how's that communication work in a scenario like that?
Yeah, well, one of our rules when we're doing business planning is, we always want two people in the bank account if possible. That's an easy fix right there. Is to have, a key employee or maybe a bookkeeper or CFO type role on there. But it's very similar to the personal planning. I always tell people that the legal documents that we do for a plan is probably about 50 or 60% of the plan. Organizing the information is the other 50 or 60%. And that changes way more often than the actual legal document. So if we set up wills and trust and we do all this stuff, over time, that may not need to be reviewed every 5, 10 years, whatever, maybe. But during that time, your bank accounts are going to change. You're going to open new accounts. You're going to change your payroll. So having a list of key people to call and where all the treasure is buried, that's usually what I say.
Yeah.
Keeping up with that kind of stuff is at least 50% of the plan, if not more.
I imagine a lot of entrepreneurs don't really want to have multiple people on their bank accounts. you know, so is that just means communication is paramount?
Yeah, if not, somebody like that, we would encourage them to try to use that trust, so that you don't
Yeah.
have the lag of going to the probate court. Like at least have, yes, that trustee is going to have to go to the bank and present the trust and have the bank add them to the account. But generally, there's a chance of that happening faster than getting to the courthouse and getting all that
Yeah.
process and then getting over to the bank. So it
Is
can still save some time.
Yeah, let's say you live in a big city, right? Like you're saying, say New York, Atlanta, San Francisco. And so there's obviously, maybe you don't want to wait for months for something like this to get processed. Is there a net worth or income level that people should start thinking about? Hey, you know what? I've got enough assets. I've got enough stuff going on that I should consider a revocable trust, period, versus just a will.
Yeah, I think, Trevor, to be honest with you, almost everyone in metro areas like you're talking about should probably have one just for the lag. I mean, I'm sure I would imagine New York City probably takes longer than Atlanta. I'm just guessing. But you do
Yeah.
raise an interesting issue there because, there are local probate considerations outside of, depending on what state you're in. So, I'm talking about Georgia mainly here, but there is a filing fee component to this. Okay. So in Georgia, the filing fee to go through probate is based on the number of pages in your will. So if you and I have the same 15-page will, we're saying we're paying the same fee, and it's generally, a couple $100s. California, by contrast, actually requires the probate fee there is based on the value of your estate. So if I have a $1 million estate and Trevor has a $10 million estate, you will pay a much higher fee to go through probate than I would. And
Wow.
you would have to value your assets and file all that with the court, which becomes a huge privacy thing. And last time I checked, it's about 6%. So it's not,
Wow.
it's not a low number. So almost everyone statewide in California would want to have a revocable trust. We have a
Yeah.
lot of people that move to Georgia and they come in and, they have the notebooks and almost everybody has one. Here in Georgia, like I say, it can be a little bit more county by county. New York is probably more similar to California, but probably a little bit of an in between.
Yeah.
So, some of that can be state and local in terms of the fees involved.
Point, right? So there's a lot of migration, right? Especially post COVID.
Yes.
Um, so moving in between states, remote work, et cetera. Let's say you moved out of Georgia to California, right? Like, and you have assets in Georgia, you have assets in California. Would you be able to have all those assets in both states in a revocable trust in Georgia, or would you need to have two different revocable trusts based on jurisdiction?
No, you can that the revocable trust can provide a lot of value for people that move around because, if you have the revocable trust, you're still going to have a will. Normally you'll have what's called a pour over will, and the will just say, I give all my assets to my trust. So it just literally pours over into the trust. So that way, if some stuff's already in the trust and some stuff is not, it all gets to the trust because the will just pours it over. And then you're going to have your financial power of attorney and your medical power of attorney, which are very local. So for clients that move around a lot, they can have the revocable trust that owns the bulk of their assets. And then when they move to another state, they don't have to redo their trust necessarily. They can just update the will and the power of attorneys, which are much more local. So a client may invest $3,000 or $4,000, $2,000, whatever, in a revocable trust and the will and all that. And then they move to another state and they may spend, a couple $100 to update their will and power of attorney only. So it can provide value for people
Interesting.
that are migrants.
Interesting. So, how often do you suggest to review the trust period? You have a kid or assets. Like, what trigger points is it just good to do it annually? Is quarterly too much? Is it, an increase of another asset? How often should you recommend reviewing, the trust agreement or what's in the trust?
I believe we recommend every 3 years, but we believe that is wishful thinking. No one does it, Trevor. I think that honestly, those records that I'm talking about,
Uh-huh.
the key people, the bank account, all that stuff, absolutely annually. Like it should be part of your financial review every year. That stuff should be updated. What's
Specifically, if
probably
you own a business.
no, in general, like even
Okay.
a family should have the statistic, Trevor, is I think it's $70 billion in lost assets in the US because people don't go claim property. So dad might have a life insurance policy through his company and it may be $15,000, but if he doesn't tell his children about it, they'll never claim it and it'll go to unclaimed property. So I think it's 70 billion. So even a family writing down, call this life insurance company, call the accountant, call Fusion CPA, call Patrick, whatever. That stuff has to be done annually. But in terms of the legal documents, we try to encourage people for what we call like life events. And so that could be having another child, or if you name your brother as the guardian and then he makes you mad, get in there and remember who are your guardians and trustees, keep that updated. Big net worth changes. If you inherit a bunch of money, you sell your business, that's probably worth a look. And then usually for us, the bigger jump is for young families whose kids become adults, because at that point, now their kids can become their medical agents and their power of attorneys. So that's usually, when their kids get to be 18 to 25, somewhere in that range. That's usually maybe that's when they do a more of an overhaul of the plan. But otherwise, it's
Mhm.
largely just maintenance for who's your trustee, who's your guardian, and net worth changes, stuff like that.
I hear a lot about unfunded trust. Like you set it up, you're like, okay, I was convinced I've set up this revocable trust, and then you kind of go about your life and don't actually title anything over, or in the case of real estate, or move other assets into the name of the trust. Can you speak a little bit to that?
Yeah, that's where the pour over will comes in. So the pour
Okay.
over will is your safety net. So if you set up the trust and you never put anything in it, like I say, the will get it there. But the money you spent on the trust may have kind of been a waste because it doesn't really provide the value of avoiding probate on anything. But
Is
that's
that is
where that
that
pour over will is so
typical
important.
general default knowledge in a will to have this pour over verbiage in there?
Usually, like if you're working with an attorney, it's always just part of the package. If you get the
Yeah.
revocable trust, you're going to get the pour over will. I did have, it was a long time ago, and I had probably not to date myself, it was probably 15 years ago, and a gentleman came in, LegalZoom had just come out, and he had only purchased the revocable trust. And a lot of people think this. They'll come in and they say, "Well, I have a revocable trust, so do I need a will? Like I'm going to avoid probate." But if you don't put anything in there, it's of no value. And I remember this guy, he had the brand new LegalZoom. The logo was on the folder that came with it. He showed me the trust, and he said, "I don't need to do anything." And I said, "Well, you've got to put your stuff in the trust." And he said, he threw it across the room and he was, LegalZoom tricked me or whatever. So that you got to have the will with the trust always. It's the safety net.
Right. Like I've seen it a lot of times. Okay, I've done my will, and then you go about your life, and then you hear about the revocable trust, and then maybe you form a revocable trust. Do you need to go back and update the will for the revocable trust so you, people know it exists, so the will knows it exists.
It's good practice. I mean, you definitely want the beneficiaries to match. Like if you're, you don't want to have the beneficiaries of the trust different from the beneficiaries of the will, unless that's what you want. But if the
Yeah.
goal is to get it to the same place, then yeah, you don't want to have conflict there. But if you did have, the beneficiaries in the trust and the will were the same, it would work itself out.
Okay. And I want to touch on the business side of it in just a sec, but like continuing on the personal side, just thinking from assets to asset, and like these days, like you mentioned, LegalZoom, it's so easy to open up a new checking savings account online, Betterment, whatever. Um, are you recommending that those accounts be, asset by asset, be named in the revocable trust, or just documented somewhere?
Checking accounts are interesting, very local. Most states are, they deem checking and savings to be joint with rights of survivorship. So if there's two people on the account, it automatically goes to the survivor. It doesn't have to go through probate. And so that's generally an easy solution with the checking and savings, is just to have your spouse or have your children on the checking account. Um, and most people do not like to title their checking account in the name of the trust, because then it says trust on their check and they just find it to
Yeah.
be cumbersome. But so there are other ways to avoid probate without a revocable trust. Same thing with like an IRA or a 401k. If you name a beneficiary on those accounts, you don't need a trust or a will. So like we have a lot of clients that don't own real estate. So they may not even need a trust or a will. If they're all liquid in bank accounts, they could just name beneficiaries and avoid the whole thing. So titling of assets is very key in what we do, and reviewing, a client specific assets and saying, okay, not only how's this title, but who's the beneficiary. That lets you know what's actually going to go through probate and can help a client make a decision on whether or not the revocable trust is even going to do anything for them. Does it even provide any value, or can they just avoid probate by naming beneficiaries?
So that's like a checking account. So what about real estate, right? So I know with LLCs, if there's a mortgage, it's a little bit of a dance. But what about with a revocable trust? If there's a mortgage, is it much of a lift? Are there issues with titling that asset, whether it's your primary residence or a rental home or some kind of real estate investment into a revocable trust?
With a mortgage, it is you do need to get by the book, you need to get the bank's permission. Almost all mortgages have what's called a due on sale clause, meaning if you transfer title without the bank's permission, it's a default of the mortgage, meaning that they can call the note due. So most of them will give you permission to transfer to a revocable trust. So if you wanted to be formal about it, you would get their permission prior to making the transfer. Usually not a huge ordeal to do that. LLCs are generally like a no-go. They won't give you permission. So that's kind of a whole different can of worms. But yes, to transfer real estate to a revocable trust, technically you would want to get the bank's permission, but it's usually not an issue.
Like what about, let's see here, like crypto accounts?
Crypto?
Rather than crypto accounts, like is that, they're not in a many times, sometimes they're not in a traditional brokerage account like a
Mhm.
Schwab. They could be all in all kinds of different platforms, or not in a platform at all, in a cold wallet. Um, any advice on that?
It's all about the titling. You have to go through the process of seeing if you can do the retitling, and if so, then obviously you would want to do it. If not, if they will not allow you to retitle, then you almost have to rely on probate. Now,
Okay.
in Georgia, I can tell you, off the top of my head, the executor always has control over your crypto, whereas a power of attorney actually does not. So if
Hmm.
you are living and you are disabled and you need someone at your access your crypto, it better be in your power of attorney. Otherwise, it's not going to happen. Whereas the executor, the will does not have to specifically mention crypto. The executor just automatically has it. But there's some old coins, Trevor, where if you don't have the keys, you can forget it. It doesn't matter. So
This is where people's heads are gonna start spinning.
it takes you got to have some specialized, you got to really pay attention to the detail with that stuff for sure.
Yeah,
And
right.
it's still evolving. It's relatively new stuff in the law, so it's evolving.
Well, and in Atlanta as well, there's a lot of kind of, angel investment community, startup communities as well. What about like, if you're a limited partner or an investor in some of these startup funds that you get a K1 from? I would imagine that's probably pretty easy to kind of rename or retitle the investment. Is there any kind of formal process that you suggest going through, you recommend going through?
For clients that are doing a lot of that, we do like the revocable trust a lot because think about it, Trevor, where you have a situation where, the serial investors that we have, they may have 10 LP interests, right? So if something happens to them, the process of getting all of those retitled to their family is a lot of work. It can be maybe more work than probate. Rare, but in some cases there could actually be a fee involved. The partnership may charge them a
Mhm.
fee to process the change of ownership. So having those in a revocable trust to avoid that hassle, that's a lot of value to the family. Or an LLC would do the trick as well, having them all in one LLC. But
Yeah.
yeah, that can be a bit of that there's definitely value in doing that.
And on the front end, right? Because
Oh
if
yeah.
the partnership's a bigger partnership and they got a big law firm and they have to amend that operating agreement, that could be a pretty expensive bill pretty dang quick.
And in some cases, it can cost you your voting rights. If you are a voting member and you pass away and it has to go into your trust, the operating agreement could convert that to a non-voting interest. Whereas if you go ahead and place the investment through your trust as a voting member, then that successor trustee will continue to have your voting rights.
Wow, that's huge. What about 401ks, IRAs? Is that pretty straightforward, or does that need to be, or the action items need to be taken there?
With those, we are usually going to lean towards naming an individual beneficiaries. Putting those in a trust can be quite cumbersome for tax because those have the withdrawal rules. Usually, it's a
Right.
10-year withdrawal. So when you add a trust into all that, it can get quite complicated on the decision making, the tax returns, and honestly, the tax rates vary quite drastically. So normally, we're going to lean to naming an individual beneficiary unless we have a beneficiary that has a special needs or a substance abuse or something like that. They just need the help.
And then final thing is asset protection, like lawsuit protection. Am I right? Revocable trust, that's not the game that it's a part of. It's more strictly for probate and clarity.
That's right. Yeah, you got to get
Yeah.
into the irrevocable trust for that. Common misconception from people reading online, but you got to get into the irrevocable trust for stuff for that.
We'll have to talk about that on the next one. Any other thoughts in regards to, best practices, FAQs that you get?
No, I think, like I say, that organization is, and I do think, well, let me add this one thing, Trevor, is talking to the family. That is something that I've started to encourage people to do more in recent years. I do find that, especially if you're going to involve children or siblings or whatever the case may be, and ask them to take on these roles within your trust, um, talking to them about it and letting them hear it from you or the client instead of the lawyer, there's a lot of value in that because there's a little bit more of a personal touch to it. Someone is likely to do what their parents or their sibling asked them to do than what a lawyer is telling them they need to do. So,
Mhm.
organizing records, talking to your family about it, like those are things that you don't need a lawyer to do and probably provide as much value to your plan as the lawyers in the legal documents.
Yeah, I've started to just, have a master list and recommend people that kind of have this master list of the estate attorney, the CPA, the insurance individuals, the financial advisors, and who to contact, what the phone numbers are, the email addresses, who to contact in what order. I can only imagine how overwhelming that could be, if there was a sudden death event. Well, actually, was there any other things on before we end on the business side that you should be aware of? Bringing in another partner into a business if it had been wholly owned, is that a trigger point to revisit a revocable trust?
Not necessarily. I think the main thing with, like I say, that we do with business planning is, it kind of goes back to that bank account and who's going to be running the company, and if something happens to the owner. So, very unique. I mean, I don't want to act like every business needs a revocable trust because there's a lot of ways to do it without the revocable trust. But I do think every business should have a succession plan. The revocable trust is always going to be a part of that. It's not that everyone needs one, but every business absolutely needs a succession plan.
Well, you're the man, dude. How many or how can people find you?
We are norris-legal.com. So check us out online. We're all referral based, Trevor. So we rely on friends and family like you to get the word out there for us. But we are available. We're online. So I appreciate you having me on today and letting me talk with you.
All right, man. Thanks a lot.
All right, you got it. Talk to you soon.